will just make it. Okay. Let's invite the officials to join us. And then you're free to go. Welcome.
呢個會議啦。各位同事
Welcome to the meeting. Members, we have tabled some papers for members' information. At the last meeting, we raised some questions and we sought clarifications, and some further questions were raised. Deputy Secretary, would you like to say something about your response to the issues raised previously? So, members, do you wish to say anything? If there's nothing you want to raise, we should proceed to the cross by cross instead of raising similar questions again. Deputy Secretary. I don't have anything particular that I want to mention. Because of the rush, we have just prepared our response to the issues and questions raised by members and deputations, and we have also provided some questions. And the questions raised by your legal advisor have also been responded to. So, members, any new questions? Anything new that you would like to raise here?
方剛議員呢就係
Mr. Vincent Fang cannot attend today's meeting. He wrote to members before the meeting in his letter, point number 3 and point number 4. Talk about anything that is in the bill that would help us prevent placing wrong order for medicines or wrong delivery or wrong receipt of delivered medicine and so on and so forth. And, of course, patients taking the wrong medicines. Yes, indeed, we would require orders to be placed in writing so as to prevent any mistake in placing orders or delivery or taking of the wrong medicine. And in the future, the Commission would require that orders will have to be in writing, and there should be records kept. In case there is something wrong about the quality of the medicine, we will be able to trace the origins of the medicines and where they have gone. So that would be in the future code of practice. Mr. Peter Cheung, Chairman, you should be the conductor here with two papers, one from Mr. Vincent Fang, the other from a number of organizations. It's a press release from Hong Kong Pharmacists Union and another one from Hong Kong Doctors Union, and another association representing patients with retinal problems. Maybe you should lead us in going over those papers. Well, Mr. Vincent Fang is not here today, so I just raised some of his questions. And in this paper, it's a joint press release from Hong Kong Pharmacists Union, an association called Retina Hong Kong, and a Drug Safety Consortium. Deputy Secretary, would you like to respond to that? Actually, we have answered your questions in writing and verbally many times concerning APs. Well, the qualifications that we required are in line with those required in the EU. But the Hong Kong Pharmacists Union, Retina Hong Kong, and Drug Safety Consortium don't seem to understand. Well, we have been trying to arrange a meeting with Hong Kong Pharmacists Union since April, and they are always saying that they are busy. And we have explained that the definition we are going to adopt is based on the EU one, but there's some change in wording. For example, they call what they call medicinal drugs, we call pharmaceutical drugs. And the definitions are on the whole on a par with international definitions. And we promise the Hong Kong Pharmacists Unions to have a meeting on the PPB, on the independent regulatory body. Actually, this is an ongoing discussion, a subject of discussion. We understand the worries of the industry, so we are going to fix a meeting. Other pharmacists have also written in. We are willing to talk to them. And actually, we agree that the two issues should be kept separate. Page 3. Please take a look at page 3. There are 5 items, 5 requests. They ask why we don't follow PICS. Why do we just follow EU standards? The first question, how many routine and surprise inspections were made in the past 3 years on local manufacturers by the Bureau? Let's get some statistics. Are you talking about AP? Or no? In the press release, page 3, please look at page 3. We request the Bureau to respond to the following issues. The Deputy Secretary has responded to the last one. How about the others? So the first question is the number of inspection, routine and surprise inspections on local manufacturers. I would like to inform members that in 2012, we inspected licensed factories 89 times. 2013, 119 times. So that's in relation to inspections to the pharmaceutical products manufacturers. We also inspected pharmacies, distributors, wholesalers, and pharmacies. In 2012-2013, we inspected pharmacies 2,408 times. As for other outlets, in the 2 years we inspected 15,172. Wholesalers 2,166 times, and importers and exporters 338 times. It's the administration's requirement that all manufacturers will have to comply with GMP. Well, they were not here. Maybe they didn't hear this, but this has been discussed. This reply was given. Whether they are happy about the reply is another matter. Anything special from members concerning the views expressed by Mr. Winston Fang and the press release from the Pharmacists Union? Mr. Peter Cho? I want to refer to the press release and the 3 issues. And that is the setting up of an independent authority to regulate the practice of pharmacists. According to the Deputy Secretary, there will be a discussion at the end of the year or early next year. I would like to know what kind of direction it's going to take. Are you going to legislate for it, or is it just a discussion? I would like to know the guidelines from the, compare the guidelines from the PPB and their own guidelines from their professional bodies. There should be a statutory system for all. Not we should not rely on guidelines from different professional bodies to regulate their respective members, which are not uniform. And then there's also guidelines issued by the PPB. I think you are just trying to give yourself some breathing space. Because if at the end of the day no legislation is proposed, it's not going to be acceptable. Well, pharmacists are regulated on a statutory basis, but it's done through the PPB, Pharmacies and Poisons Board. In the future, pharmacists will be regulated by its own body. Pharmacists have to be registered, and they are regulated by the PPB. As regards the details in the future regulatory system, the composition of the regulatory body, and so on and so forth, all these will require legislation. We understand that the professional sector may not agree on the details. Pharmacists play different roles in different places. It can be a licensed person, it can be a licensee, it can be a professional. So they play different roles within the chain of medicine supply. Chairman, first of all, I must stress that there should be negotiation and discussion. Don't just say that it's difficult at the very outset. Maybe at the end of the day, you cannot agree on setting up a single regulatory body, and then the fallback will be to go back to the PPB. If we say we don't like the way PPB carries out its duty, then of course the professional sector would have to do something, and of course it's going to require assistance from the administration. It's much easier for the government to table a bill than a private organization. Now you are all telling us your side of the story, and you don't agree with each other. The bill doesn't contain such details, but some of the clauses are related to PPB, and the guidelines issued by the PPB would affect every pharmacist. So we need to clarify the plan, and then we can leave it up to one side, and then we will leave the matter to the administration for discussion with the pharmacists. Well, there was one meeting already. Actually, there's a subcommittee set up on manpower. The direction proposed, or the direction that we agree, is to go for another statutory regulatory body.
即係我嘅理解咧，就係並冇咧就係改動任何關於規管藥劑師呢部分嘅，係咪？係。啊，淨係講緊規管藥物嘅啫。規管藥物。咁但係即係呢一條條例咧， 又咁啱咧，又係規管藥劑師，又規管藥物。咁但係你哋今次就係淨係改一啲因為即係09年發魔藥事件而導致嘅一啲藥物嘅一啲嘅漏洞又好，或者錯漏都好啦，修訂翻佢，希望咧就堵塞咗呢個即係藥物發魔事件重演有一啲嘅問題。而呢啲問題咧，基本上根據個報告書講嘅問題，係咪咁樣？嗱，咁而嗰個藥劑師呢個專業本身，佢哋覺得佢哋應該有一個獨立嘅一個團體又好，或者一個法定團體又好，或者一套法例都好啦，去規管佢，呢個係另外一樣嘢嚟噶嘛，係嘛？即係但係即係佢哋想你將呢一個條例分開啦，清楚分開，就係將佢呢個藥物就管藥物，人就管人咁樣樣。咁但係今次呢個條例，即係我想讓同事清楚就係今次呢個條例嘅修訂咧，並冇咧就係改動任何呢個規管藥劑師呢部分嘅。咁但係如果你哋都係講咗好多次，你哋同意呢個方向嘅，不過咧就係要再咧去探討點做。咁呢個係另外一樣嘢。咁我諗今次讓同事睇清楚就係。
So, if you want to make an amendment relating to the regulation of the professionals, I don't think that is covered in the bill. Mr. Albert Chen, I think it's very difficult for colleagues to scrutinize the bill. The disputes involved as a layman, it's difficult for us to make a judgment. The government is imposing this upon us in the name of public interest, and it's very difficult for us to really deal with the government. I think we must clarify all the concepts and principles, otherwise it wouldn't be a meaningful exercise to scrutinize the bill. I hope that the Secretariat could help us here. I've raised many questions previously. The pharmacists associations and the doctors associations have also raised various issues. Could the Secretariat compile a table outlining all the issues raised and what are the government's responses? I raised a very important point which the government has not yet provided a clear explanation. The government always says that they are proposing to adopt the EU system. If you want to copy the practice of other jurisdictions, are you copying the entire system, or are you only copying parts of the system and not the whole? I think we could be easily fooled. I mean, if you tell us that you are going to, adopt a EU model, we could be easily fooled. So I really would like you to tell us clearly what are the principles behind the proposed legislation. Otherwise, the government will be saying A, and the Farmers Association say that it's not so. So we have all these, arguments, and we don't know when we'll be able to resolve the whole issue. I hope there could be a clearer picture so the members can judge who is right or wrong, and then, make their own judgment. If that could be done, it can certainly help me to have a better picture and be able to come to a sensible decision. I think with respect to what Mr. Albert Chen said just now, the administration has issued several papers. That is, the government has issued one paper, which is CB2 1735 1314 bracket 1. I don't know whether Chairman, I understand that the different documents have responded to the different issues raised, but other than what I've said and what other people have said, I hope this research department could also give us some independent, assessment on major issues. For example, the EU standard and the EU standard suggested by the government. well, we don't have time to conduct research, and we are also not familiar with this subject. Like planning and lands, I can easily tell whether or not the government is lying, and I can criticize Mr. Paul Chen. But this is a subject which I'm entirely unfamiliar with. And in respect of many of the things which the government is saying and the deputation is saying, I am a bit skeptical. I'm not entirely against what the government is proposing, although I often, are against the government's stand. Yes, we can certainly ask the Electrical Secretariat to prepare a summary. At least I have 3 papers which outline the government's responses to the various issues raised by different, stakeholders. So we will sum up all the major issues raised, what had been discussed, and how the government had responded. In that case, could the Secretariat also help us? Given that the documents are scattered, and sometimes we may miss some of them, could the Secretariat help us? Could the Secretariat give us a brief summary of all the important issues so that we won't miss any of the documents? Over the past 4 meetings, I've asked the Secretariat to prepare a summary of all the issues which have been raised many times. Hopefully this can help our members better understand all the issues. Do colleagues have any further points? I'd like to discuss all the concepts and the principles before we go into the clause by clause. Well, I've said last time that the amendment of the ordinance are mostly amendments to terminologies, and there's very little which involves the principles. We're now in the mid of June, and if we were to hold another meeting, then we can only come back in September to October. We will not be able to finish the scrutiny of the bill at this stage. But for those technical amendments, such as the amendments to the text of the bill, we can deal with those first. And if members believe that there are certain concepts which have not yet been clarified, we can leave them, put them aside for the time being. Otherwise, if members have no new points to raise, and the government has already made its response, we may as well adjourn. Or should we? You make a start anyway, and if we identify any problems, we can put it aside, and then pending the supplementary information to be given to us. Chairman, we have not yet gone to the clause-by-clause stage. I would like to refer to Vincent Fang's paper, and would like the administration to answer some questions. Just now we highlighted some of the points, but starting from paragraph 5 to 8, all these are very specific issues. Could we have a discussion on those issues? That is, how does the government, interpret the questions, and what is the government's response? Although Mr. Vincent Fan is not present today, but I think we can have a discussion anyway and see what is the government's stand. Later on, the government could reply to Mr. Vincent Fang in black and white, but we would like to know. Perhaps that could help trigger some discussion. Perhaps at this stage we can look at Mr. Vincent Fang's letter. I believe all of you have a copy. We can perhaps try to look at this paper, and we'll start with point number 1. We'll go through all the points and ask how the government would respond. The first point, Mr. Fang asks why we have this bill, because we have the incident involving the dispensing of the wrong medicine, and I think this actually takes us also to the third questions he asked, and that is whether or not there have been, which is about the question of ordering the wrong drugs or delivering the wrong drugs. The second point Mr. Finn is raising is that the administration not yet consulted the profession. But I believe we already had 4 rounds of discussion previously. We don't have to argue whether or not there's any that is sufficient, and we don't know whether or not there are new, organizations which have been formed during the interim. The third point is about the problem of ordering and delivering the wrong medicine. I think this has been covered before. Point number 4, the only relevant issue is that the government should, the PPP should publish a set of codes, practice codes. Why is it that without involving whether or not the government has not yet informed the board before the codes were amended? I remember during the public hearing the chairman asked the same question, whether or not we were hiding the facts. There was one deputation saying that he was a member of the management committee, and he said that he understood the bill and that they have scrutinized each and every provisions in the bill. There were also other members of the management board present who gave an answer. And the code of practice, regarding code of practice, we've already responded to members that we will be setting up different working groups, including all the professional bodies. We gave a table listing all those organizations. They have the Hong Kong and Kowloon, Medical Retailer Association, and Professional Pharmacists Associations. They were all present on that occasion. I don't think you have 4 working groups working on this bill. I don't think it is possible for us to hide anything. All right, we now come to the 5th point, that is the content of the code. That other than that medicine would need to be ordered in writing, is there any way we can prevent the private clinics for ordering the wrong drugs and so on? I think we would now require the clinics to order medicine in writing, so that we would know when they order the drugs and the quantity that they've ordered, so that we can follow up accordingly. The next point is about how we can prevent incidents involving the ordering of the wrong medicine or the dispensing of the wrong medicine. Again, our answer is the same. In the guidelines, we are stepping up the regulations regarding the delivering, the ordering, and the taking delivery of the medicine. With the records in place, it's less likely that there would be mistakes, because everything is recorded in writing. Since we have an insufficient supply of pharmacists, and the private clinics do not need to hire registered pharmacists, I don't think this would come under the ambit of the bill. When we proposed earlier on that the drugstore would also have resident pharmacists, there was the complaint that we have insufficient supply of pharmacists. Could you tell members that in the private clinics, who is responsible for ordering the medicine, and when the mistake is made in the delivery or the ordering of drugs, who would be responsible? Perhaps my colleague can further. Who is the authority to order the drugs? I mean, in theory, it should be the medical practitioner who should order the medicine. When the medicine is being delivered, many drug manufacturers would require the person taking delivery to sign and acknowledge delivery. And when the drugs are being delivered, the doctors may not be present in the clinic. He could be, performing an operation somewhere. So perhaps my colleague will explain how we will make improvements in terms of regulation. In private clinics, it would be the doctor who is responsible. In the PPBO, we do not regulate the doctors. We only regulate the pharmacist profession. In the clinic, the doctor has the duty to order the drugs, and I believe in the actual circumstances of the clinic, the doctor would authorize his assistant to do that. But ultimately, the doctor would have to be responsible. When he takes delivery of the medicine, he would require, say, a nurse to take delivery. And if anything should go wrong, the doctor will be the person who will ultimately be responsible. The ordinance regulates the drug manufacturers. When they deliver medicine to a doctor, they can only deliver medicine to licensed persons. If for a wholesaler of poisons, then they can deliver the poisons to drugstores or pharmacies. And doctors is one of the doctor's clinic is one of the places where medicine or poisons could be delivered. So we are not regulate the doctors. The purpose of the bill is to regulate the pharmacist profession.
Mr. Peter Zhang, let me try to understand this a bit better. The ordinance regulates drug manufacturers, and they're in business, and when something happens, when there's a problem with with a drug, and therefore to facilitate your follow-up action, you would like to know which pharmacies have purchased the drug, and then you can order a recall. And if the drug is of substandard quality, and then the doctors and the pharmacists may have to help you with your investigation, or they may be found to be involved. So you may need the assistance of doctors and pharmacists in your follow-up investigation, and that's why you require them to show the certain responsibility. Is that the case? Well, it depends on the case in question. Let me give you some instances just for illustration. For example, you don't regulate clinics and pharmacies. You may need their assistance, the assistance of doctors and pharmacists in some instances. But we want to protect the public. The responsibility that one has to shoulder is dependent on the provisions in the ordinance. And there are also guidelines. Here we're not talking about breaching the law. We are saying that there should be guidelines, and there should be supplementary requirement. So there are some drugs found to be problematic. We can order a recall faster. Or for example, we can do something about a particular batch. Maybe the problem is just with one particular batch and not with all the medicines produced by the same manufacturers. Mr. Zhang, you have raised a very big issue. Many problems can happen in the processes, although there's no requirement on placing orders in writing by doctors, but there are guidelines of certain professional bodies that it should be done in writing. And sometimes the patient is given the wrong medicine, and the doctor should have checked the medicine before they are dispensed. In some pharmacies, well, they sell drugs without a prescription from a doctor. Then there's another problem. As for the placing of order by pharmacies, if we are talking about poisons, there's a a requirement to do it in writing, and there should be records. Sometimes the records do not tally with the stocks. And then if in the future, after dispute is passed, we'll know where the problem lies. For example, if the quantity exceeds the ordered quantity, then there's a problem. We want to have proper records kept. And then if there's a problem, you know where the problem lies and the reason why there's a problem. And then we can pursue the question of who is to be held responsible. So check and trace is the very first thing that we would like to achieve through the new bill. Of course, I understand that there are many reasons why a problem happens, and of course there are instances whereby the law will not be able to cover all eventualities. But I need to clarify a point. Clinics are not regulated right now. But we regulate drug manufacturers, the sale of drugs by drug manufacturers to doctors. And the drug manufacturer will tell doctors that I won't accept telephone orders. Please fill in the form and place your order. And then the doctors have no alternative but to oblige. Well, they can have an order form, like an order form for dim sum. But anyway, the drug manufacturer will always insist on something black and white. And the doctors would just patronize a drug manufacturer who receive oral accept telephone order. Let's say this bill is enacted, and it must be done. The order must be placed in writing. But you don't require the doctor to do this in writing. He will just call a drug manufacturer who accepts telephone orders. Can I put it like that? I think, sorry, Mr. Cheung, it's a layman's view. Sorry for that, Mr. Cheung. What's the difference between before and after the bill is enacted? And now the drug manufacturer is not required by the law to receive, to accept orders, to deliver drugs. Say I am a drug manufacturer. I'm a licensed manufacturer. A clinic calls me, okay. Fax me, okay. Or write something to me to place an order, okay. That's also okay. And I deliver the drugs as ordered. And now you require that it must be that the order must be placed in order. And if I'm a doctor from a private clinic calling, making a telephone call to order a drug, I will say sorry, please do it in writing. All right, he would ask Mr. Zhang, another drug manufacturer, to place an order over telephone. Mr. Zhang, the drug manufacturer, will say no, I'm regulated by the law. But would they be able to find an intermediary to do it for the doctor? Well, it's good for the public because it's regulated, it's in writing. But for those who are now placing orders over telephone, it's less convenient. I'm not talking about any intermediary. Well, Mr. Zhang is suggesting a possible scenario, but the intermediary is in breach of the law, conceptually. From a layman's point of view, the difference before and after the enactment of the bill is that before enactment, there's no requirement imposed on the drug manufacturer that he cannot accept orders made orally. After the enactment, the drug manufacturer can only accept orders in writing to the one who has been, or the user, the purchaser, who has been doing this over verbally or over phone. It's more complicated. They're saying, no, I don't want it. Well, whether it's an order form, standard order form, or an electronic communication, email, whatever, everything would be accepted. Instead of a telephone call, which can never be traced afterwards. But the user is saying that this is still not good. This is going to cause me inconvenience. But that's why, well, I guess, as regards their reasons for their objection, But you want to protect the public. You want to ensure public interest. Well, we have been talking about the requirement to place orders in writing many, many times. Sorry. For the newcomers, please be reminded that we are talking about Mr. Vincent Fang's letter, point number 5 and point number 6. Because we don't have a good system, we don't have anything to address the possibility of wrong delivery, wrong orders, or wrong drugs being dispensed. So that's why you propose the requirement that orders can only be placed in writing. But in a private clinic, there's no requirement on employing a pharmacist to manage the drugs, because the doctor is already empowered to do this himself. But there are two sides. The drug manufacturers can only deliver drugs upon receipt of written orders. Otherwise, it's a breach of the licensing conditions. So the license can be invoked. The drug manufacturers can also be disciplined. But some people find it troublesome. They want to breach the law. They want no one to be able to trace the order. Then that's difficult to make them happy. Well, I just gave an example, which is not uncommon. I talk about an intermediary. It's against the law. A middleman, a go-between. Maybe it's a staff member, a salesman of the drug manufacturer, who would deal with the pharmacies and clinics. At present, it's done over phone. And the salesman will say, okay, I'll deliver the quantities required. And then the staff, the salesman and the staff of the pharmacy will have to do this in writing. I think Mr. Vincent Fang is suggesting that pharmacies are not going to be regulated.
Clinic.
If you deal with a drug manufacturer, you have to do it in black and white. But if you are dealing with a salesperson, then the salesperson would do everything for you. The doctor would just trust the staff, or there will be some sort of communication between the doctor and the salesman, and whatever, and there's something to untoward happens, but the salesperson will shoulder the responsibility. Clinics are involved in the creation of the documents in black and white. That's the current situation. Let me explain. We need the doctor to sign the order in writing. if the salesman says I receive an order and the drug manufacturer provides the drug for the salesman to deliver to the doctor, it's against the law because the drug manufacturer has never seen an order in writing. We require the drug manufacturer to only accept an order signed by the doctor. Unless the middleman forged the signature of the doctor and deceives the drug manufacturer or his employer. So I'm confident that it's definitely going to be better than what we have now in terms of regulation. We are asking for orders to be placed in writing. I don't think members should focus on how things are done in the industry. Let's just wait about which interests should be given first priority, public interest or the convenience of people, or whether we should allow telephone orders to be made vis-a-vis anything in writing. And it's said that you can place an order over phone and get the drugs in 2 to 3 days, but if it's in writing, it's 7 days.
The inconvenience, to resolve the inconvenience, you can order the drug by telephone and then supplement it by a written order. I think the main purpose of the amendment is to protect the people who use those drugs. And we've learned from the experience of in the past, and this was a recommendation made in 2009. So I'd like to invite the community to actually to weigh the inconvenience cost and the benefits of the proposed regulation. Before the amendment, you did not regulate the clinics. After the amendment, you are still not regulating clinics, but then in a roundabout manner, you are now requiring them to place the order in writing, even if they were to do it through a salesperson. I think the proposed amendment only regulate the drug manufacturers, same for the code. Whether or not it's convenient for the drug manufacturers, not our concern. Our concern is drug safety. If you regulate the manufacturers, however, inadvertently you also affect the users, and the users saying you're also putting regulations or imposing regulations on me, and I'm not too satisfied. It's like the Deputy Secretary said, even after the amendment, the ordinance doesn't regulate them. But it will more, effectively regulate the wholesalers, the manufacturers, and they can only deliver the medicine after they receive written order. And after the medicine is delivered to the clinic, it must be the doctor who signed and accept the drugs. So if he placed should he order the wrong medicine, he can actually trace the order and find out what has gone wrong. After the amendment of the ordinance, will the interests of some people be affected? Obviously, that is the case, and that's why we have all these views being put forward. If members believe that we need to protect the interests of the clinics, fine. But I have the responsibility to point out clearly to members what will be the difference, before and after the amendment is made. Mr. Cheung, do you have any further views? We have 3 members who put up their hands: Ms. Alice Mack, Ms. Wong Ting Kwok, and we have plenty of time, Ms. Mack. Chairman, I think point number 5 and 6 is in Mr. Fang's question. If we also look at the letter from the Doctors Union, saying that those who blindly support the proposal requiring order to be in writing, they say that there is no evidence to prove that this method is superior to the conventional and efficient oral method. So the question is, would there be any delay in obtaining the correct medicine? Why is there a delay? I don't understand. Why is it that if the medicine were ordered in writing, there is a delay? Have you tried to find out from the manufacturer? If they were to receive orders in writing, there must be a delay that they cannot, and they would definitely have to, take a few more days. I don't understand that, because once an order is made, the manufacturer would like to deliver as early as possible so that they collect payment. Why is it that when orders are in writing, they can only collect payment at a later time? Thirdly, I've heard from some doctors saying that when they order medicine and they take delivery of the medicine, they also follow certain, codes or practice. Could you provide to us the information or guidelines or codes which the doctors have to follow if they were to order drugs and to take delivery? I think the issue is very clear. Why is it that the manufacturers believe that, order in writing will cause delay in the delivery of drugs? We don't understand this either. I already gave the example that the doctors' union is saying that if they were to order in writing, it takes 5 to 7 days. If they order through the telephone, it's 2 days. We don't understand ourselves either. It is very strange that the Manufacturers Association supports a proposal that orders should be done in writing. The drug manufacturers, yes. Could you explain this point more clearly? Because most members are laymen. They're worried that if they deliver wrong drugs, then they cannot take it back because they, for the sake of safety, once it is delivered, they will. So if the wrong drugs are ordered or delivered, it's actually to their disadvantage. When orders are made in telephone, the quantity, the name of the manufacturer, the quantity, I think mistakes can easily be made. If orders were made in writing, it's certainly better because the doctor would need to write it down and read it over once before forwarding it to the manufacturer. It's not just like making a telephone call. If the call is made through a cell phone and the reception is not very clear, mistakes can be made. So the protection is much better. Otherwise, you wouldn't have the incident in 2009 when a patient died because the wrong medicine was ordered or delivered. Although the Hong Kong Doctors Union is against this proposing, in the GMP practice, it is already recommended that doctors should order drugs in writing. And, for example, doctors who work in clinics, there are guidelines regarding how they should deal with the drugs. That is, the guidelines of the Hong Kong Medical Association, which of course is regulates the members. What about the members not following those codes? Then they will be in breach. Well, the Medical Association is not a statutory body. The Doctors' Union actually is the union of GPs operating in private clinics. I think just want to give members the background. Well, actually, not all doctors make the orders by telephone. There will be salesmen, visiting the clinics to sell the drugs. So if they order in writing, they can simply, the doctors can simply fill in the form and sign those forms and give it to the salesperson. I think we have a very protracted discussion on this point, and we still don't understand where is the inconvenience. So how serious is that inconvenience? At the practice in the profession, it seems to be different from our understanding. Understand that. You say that in 2009, we don't know whether the problem was caused by the ordering or the delivering of the wrong drug. Did the patient or the family of the patient lodge claims afterwards? And to whom did they lodge the claim? I don't know whether or not there was any claim lodged. What happened was that the doctor ordered drug A and the wrong, so I don't know what happens, and then the nurse put the drug into the container and it would turn out to be drug B. Now, with all these, guidelines, would it make it more convenient and easy for the patients if they need to lodge claims? Yes, it's certainly. I think safety is the most important. First of all, we have to identify where the problem occurs. To ensure there is safety, you have to find out where it is most likely that mistakes will be made. If mistakes are still made when orders are made in writing, you can still go check where the problem has occurred, whether or not it's at the stage of the when the drug is ordered or when it was delivered. When it is all in writing, people also tend to be more careful. So as a result, I believe that requiring orders to be in writing will certainly be much safer. And there wouldn't be any unnecessary disputes because you can easily find out who has made that mistake. So as a background, we were talking about the private clinics. As one of the users, they believe that they are indirectly being regulated by the proposal in the bill, and many members of the Hong Kong Doctors Union is expressing this view. Mr. Wong Ting Kong. I know that this is a letter from the Hong Kong Doctors Union, but they is claiming that the delivery by drug manufacturers will be delayed by this proposal. I don't know why the Doctors Union can say this on behalf of the drug manufacturers. Of all the drug manufacturers which I have been in touch with, they all indicated that they welcome the proposed amendment. What the Deputy Secretary said was right, because when the wrong medicine is being delivered and when they are returned to the manufacturer will not deliver them to another doctor again, because such medicine will certainly be destroyed. So for the manufacturer, their attitude is positive in respect of the proposed amendment. Since the purpose of the amendment is to protect public safety, I hope that we can try to eliminate as many loopholes as possible. Safety is most important. Accountability is of secondary importance. We don't want a problem to occur in the first place. That is the most important. When an incident happens, then even if you can hold somebody accountable, it's not. Then you still cannot prevent the incident from happening. So from the operational aspect, I mean, I like the Bureau to further clarify. Mr. Zhang raised the point about ordering by telephone. Actually, the drug manufacturers, when they sell drugs to doctors, they hire many salespeople, visiting the doctors at their clinics and ask the doctors whether they need to order any drugs. The salesperson will take down notes, and the staff at the clinic may perhaps put down the signature. They may not put down a signature. The salesperson will note down the drugs that the clinics require and go back to the manufacturer's premises and then arrange for the drugs to be delivered to the clinics. Sometimes when the clinic urgently needs a certain medicine, it's very easy for them to call up the salesperson over the mobile phone, and the salesperson again will note down, for example, Dr. So-and-so would require that particular medicine. Now, after the amendment of the ordinance, we're not saying that it should be in writing, but rather there should be written record. Other than requiring it to be done in writing, whatever the paper, there must be records. I think the clinics can also order through apps and SMS. If I were a doctor, I call up the salesperson and say I want something, certain quantity of drugs, and the salesperson can fabricate an SMS message. He goes back to his office. Then what are we going to do? The doctor has just called the salesperson, and the salesperson fabricates the app's message or the SMS because no signature is required. For apps and SMS, there's no signature, and then a problem would occur. When the company receives the order, and if something goes wrong, should the company be responsible, the doctor or the salesperson be responsible? I have less contact with doctors. I have more contact with the people in the trade. The manufacturers are of the opinion that they have a positive view regarding the proposed amendments. They want the loopholes to be plugged as far as possible. They welcome the proposal that the order should be in black and white, but now you're proposing to allow orders to be done by SMS and apps. They think that there might be a loophole there. And, well, while you have clarity because you have the order in writing, but the question of accountability, still cannot be resolved.
Sorry for the interjection. Whether it's in writing or it's electronic communication, what we want to do is to trace the origin. And then I'm the salesman. I write a message, and I write a message to the drug manufacturer. The drug manufacturer will not deliver the drugs because the message is not from the purchaser. Or you can just CC the message to Dr. Wong, and then the printer version will know that this is an order placed by Dr. Wong to Mr. Wong, the salesman of the drug manufacturer. So I think the principle is that we should be able to trace who is responsible for what. Chairman, what you say is correct. The question is, if you use an app or if it's an SMS, of course, you know the sender, the sender's telephone number, and also, but sometimes the number can be hidden. You can refuse to disclose the caller's number, and if the drug manufacturer receives a message like this, should the order be accepted because you allow the order to be placed through such a message? And if there's something happens untoward happening, which happened afterwards, who is to be held responsible? The salesman is the employee of the drug manufacturer, so the drug manufacturer will be held responsible. If anyone is to be imprisoned, punished by imprisonment, it will be the drug manufacturer. I think we need to safeguard public interest. We don't want anyone to get the wrong medicine, to take the wrong medicine. But then the drug manufacturer will also suffer because they may be held responsible. The administration would like to make it convenient for the placing of orders, for the delivery of drugs. You don't want to make it difficult for people. But there is some sort of a loophole. because of the allowance that you are given. Let's see how we can practice it. Has the Bureau considered how we can handle those problems? Chairman, I think Mr. Wong has raised a real possibility that the industry may, for the sake of convenience, cut corners or bypass certain procedures. The purpose of doing all these is to trace the whereabouts of the drugs, and the code of practice will require that there is something, it must be something that we can trace the identity of the purchaser and the recipient of the drugs delivered. If the drug manufacturer accepts a message which cannot do this, it's already a problem. And of course, the drug manufacturer doesn't want to see problems. When we compile the code of practice, we consulted many people, and I think the drug manufacturers should advise their staff, their salesmen, not to do anything Mr. Wong has suggested. It's difficult for the salesman to get a different telephone to place orders for all his contacts. We are trying to do everything we can to help the salesman to get the confirmation required. For example, the salesman can use a standard order form, and then there can be written confirmation in writing or in some sort of electronic message. And I think the drug manufacturer can certainly give proper advice to the staff. Now we have heard from the two very important professional bodies. If they continue to place in the future, the doctors continues to place his orders over telephone, and he just rely on the salesman to complete the documentation, then it's actually a violation of the professional code of conduct and the law. When we enforce the future code of practice, we would certainly find some way to help the drug manufacturers, the salesmen, and the doctors to comply with the requirements. And at the same time, the inconvenience will not be too much to bear. Placing an order in writing is not really difficult. Although sometimes there are urgent orders, well, the salesman can just send an e-message for confirmation. What the doctor needs to do is just to press a button to confirm it. If it's a WhatsApp message, what he requires is to send a WhatsApp message to the doctor, and the doctor can just reply by two letters, OK. I believe the industry would be able to find something feasible and lawful, but we should not assume that people would resort to the deception or fraud, and we should not assume that the salesman would deceive the company that employs him. Why do we allow the flexibility of using electronic communication? Well, it's the trend, and also it's easier for record keeping. You don't need to keep the fax paper. Fax paper tends to turn yellow over time. If it's an electronic message, it's easy to store, it's easy to retrieve. But we'll bear in mind the real issues raised by Mr. Wong, and we will try to address them in the future code of practice. And we'll also work out something with the drug manufacturers. For example, maybe there's a procedure to seek confirmation. Have you talked to the drug manufacturers by way of a seminar or workshop to address the issues that Mr. Wong has suggested? And that is to say, after the bill is enacted, well, they will show the certain responsibility, and they should avoid doing certain things that may help them, that may make them liable. Yes, it's not about regulation of drug manufacturing. There will be a license. We are going to organize briefing sessions for the industry, and good practice will be promoted on how to implement the core practice, so that they will be less likely to be in breach of the law and the code. And in this code of practice for licensed authorized drug manufacturers, 206 representatives attended a seminar organized in 2013. We can do more after the bill is passed, because the bill would cover other stakeholders as well. Well, thank you. If the salesman receives a telephone order from a doctor, he can send a message not to the drug manufacturer, but to the doctor for confirmation. That's a good solution. I will tell the drug manufacturer about this solution. This is a good suggestion from the Bureau. So let's work out more solutions so that more people will be willing to accept the new law. Mr. Leung Yu-chung, as a third party, whether we should accept, we should require orders to be made in writing. It's not a big issue. What we want to make sure that there should be no mistake in ordering and dispensing drugs. I've been trying to listen to both sides of the argument to see which one should be supported. That's my position. That's my stance. The Bureau has given us many positive things about requiring orders to be made in writing, but I don't know whether you have received from the pharmacies organization, Hong Kong and Kowloon Pharmacies Association, Trade Association. It's been said that some people object to this requirement. Not many, but there are people who have accepted this. We are told that the pharmacies have already done this. There's no objection. When the requirement was imposed on the sale of poisons, we raised objections immediately, and we gave reasons. So the pharmacies association, the pharmacies trade association also raised objection, and it's really ridiculous to suggest that doctors, some doctors already did this. we have consulted our members that none of them had ever done this. So it seems that there are many versions of the situation given by different parties. The Bureau says the new requirement will have minimum implications, and that the administration has suggested that Part 1 poisons will be covered in the first instance, and later others will follow. But if you look at drugs to deal with different diseases, diabetes, osteoporosis, and antibiotics are all Part 1 poisons. Among the 19,000 drugs, more than half belong to Part 1 poisons. And most clinics, pharmacies, and elderly homes order drugs which are Part 1 poison. And it's said that at present the records are insufficient to trace the whereabouts of drugs. But the other side of the story is that the current records are already well established. There's no need to go for additional measures. This will add to the cost without any benefit of ensuring the quality. The drug supply chain is a very intricate and interlinked one. They have given us the details. So I think we should listen to both sides. Last time you told us that you organized many briefing sessions, you met with many people, and their side of the story was that on the 20th of August 2012, there was a briefing session for authorized poison salad. Many of them were unhappy about the code of practice and asked for amendments. On the 27th of November 2012, the administration conducted a briefing session. 147 authorized sellers of poisons attended. Well, there was an uproar. They left in protest because of the fake consultation conducted by the Department of Health.
So what I'm trying to say is whether the administration could give us more details so that we can have a better basis to make a judgment. I'm not saying who is right or wrong. I just want to have a more detailed understanding. That's all. Thank you. Well, this is not a paper which is tabled today, but rather circulated. It was circulated earlier to members. Yes, indeed, we are conducting such, doing that. For Schedule 1, the so-called ASP, authorized sellers of poisons, they're selling poison. So, according to the license, all Schedule 1 medicine should, for such medicine, there should, proper records are required to be kept. You say the impact is minimal, and Mr. Leung is saying that the impact is really, significant. There are different types. I mean, these are sold by the pharmacies and not the clinics. The letter is coming from the pharmacies. The pharmacies are now selling poison. They should have pharmacists. This is the Hong Kong and Kowloon Pharmacies Association. So they are ASPs, authorized sellers of poisons. So since what they're selling are poisons, and poisons are subject to regulation, so when they order the poisons, they're already doing this. What do you mean? Could you give colleagues some background here? Now, Mr. Leung Yu Chong referred to the letter from the Pharmacists Association. Their members basically are people operating community pharmacies. If these pharmacies want to sell such poisons, they must obtain the license of an ASP, and there should be a resident pharmacist working at a pharmacy. We are no longer talking about the requirement for private practitioners to order drugs in writing. We're now we're talking about the pharmacies within the community, and they are already subject to regulation. It has nothing to do with the clinics. Right? This booklet doesn't regulate the clinics. So I'm getting a bit confused. With the point about ordering drugs in writing is about clinics. The pharmacies already have a license to sell poisons. Now, Deputy Secretary, according to the existing ordinance, how are the pharmacies being regulated at the moment, and how would this change after the amendment is enacted? The authorized seller of poisons, when they supply Schedule 1 medicine, before the completion of the sale, they must obtain the written order from the purchaser stipulating the name and address of the purchaser before they can sell the poison. So here, because of the licensing requirement, they have to comply with such requirements. Regarding the requirement for written order medicine, it's because the manufacturers have to sell drugs to the clinics. And now the transaction is being done, facilitated by through salesmen. So anyway, the person who sells the drugs must receive. Previously, he was a doctor, and no written orders required. But now we're proposing that it must be in writing. If the medicine falls under the Schedule 1 and they are poisons, if we are only to require the doctor to start ordering such poisons in writing, the impact would still be significant. That's true. But then, on the other hand, these are really poisons, so the impact is more serious. Even if there are many poisons, they're equally serious, and we would still require written orders. It shouldn't be the case that if the order is in small quantity, then no written demand order is necessary. We're talking about poisons. Any taking the wrong poison could have serious consequences, as in the case of the patient who took the wrong medicine to treat diabetes, and the patient died as a result. You're right. We have conducted consultation, and they have expressed different views. In our consultation, we explained to the trade what we propose to do, but it doesn't mean that we should accept all their demand. The Farmers Association is being very honest. They say that we've conducted many briefing sessions, but we've not, agreed to all their requests. We told them at those sessions that we cannot entertain or accept all the recommendations because an incident had happened. Is a matter of point of view. Consultation, according to the definition, said we must accept all the demand or requests before we call it a consultation. Let's not argue whether or not there have been any consultation. I'd just like to give more background for Mr. Leung. That is for the Hong Kong and Kowloon Pharmacies Association. The members are actually operating pharmacies at the community level. For these pharmacies, if they want to sell Schedule 1 poison, how can they do that? If they want to sell such medicine, do they have to have an AP before they could do that? For Schedule 1 medicine, you would require an order in writing stipulating the name, the address, the profession of the buyer, and the name of the drugs being ordered. If I want to set up a pharmacy myself now, can I sell such poison, such medicine, let's say I set up a pharmacy. It doesn't have a Red Cross sign. Mr. Leung may not know this very well. If I set up a pharmacy, an ordinary drugstore, if it is not allowed to sell such medicine, then they will not be affected. Only drugstores with a pharmacy sign, they have to obtain a license as the ASP. So pharmacies with a pharmacist sign must have a resident pharmacist at certain times, and all the medicine and poisons will need to be locked up. So they already require to require orders in writing. So the background is different, So what we don't understand is that they're saying that even if we were to implement these proposals in stages, the impact will still be serious. I think, but even for them, they have to order in writing. I understand that the practice of the trade is very complicated, but in a nutshell, Mr. Leung, just bear in mind that if the medicine is a poison, do you think that it is safer for such poison to be ordered in writing than verbally? Would you say? Do you think that it's very inconvenient for them if they could not order by the telephone, over the telephone? I think the rest would really, the rest of all the other issues are not really that important. As a electoral member, I'm a layman. I don't know too much about the industry, and I don't want to come up with a hasty decision. But then I still have to listen to the views expressed by the trade and ask you for clarification, because I have a duty to do that. And thirdly, they raise certain points, and I have to respond and judge whether or not those points are valid or not. I cannot simply accept whatever the administration says. They've said that it's not that they are against the requirement for a written order. They're simply saying whether or not this could be, whether you could, enforce this with the existing system in parallel. At the moment, there is a system for checking the records. You have the poisons registration form. All those are in place already. I don't want to read out the full text of the deputation submission. Otherwise, it will take a long time. They've already told us that there are already procedures in place. Records are kept to ensure safety, and drugs are not sold indiscriminately, because the medicine we're talking about is poison. They say that all these records are already in place, the files are already in place and could be traced. Is that a valid point? They say they don't mind if both systems could run in parallel. I just want to know more. Could you give me a more detailed explanation? You're saying that they should be allowed to order either in writing or by telephone. Ms. Private Secretary, could you explain further to Mr. Leung? For pharmacies with a pharmacist sign, a Red Cross sign, you have an authorized person responsible for the sale of Schedule 1 medicine, namely poisons. In the course of selling such medicine, must they comply with certain requirements? Secondly, if they sell these drugs, they've sold all the drugs, they need to order from the manufacturer. The law now, what is the difference between the situation before and after the amendment is implemented? With these amendments passed, will there be any change governing how the way these pharmacies sell such poisons? If the stock is already all sold and the pharmacy need to place an order, then you now propose that they must place the order in writing, while it's not required at the moment. but they will have to after the amendment. So could you explain further the difference to Mr. Leung? Perhaps Linda could, you're the expert, perhaps you can further enlighten us. We're talking about the seller of the poisons. If he were to sell such medicine, what is the difference before and after the enactment of the bill? The manufacturer supplies the drugs, they're different from the pharmacies. We're talking about the pharmacies, the drugstores, the community pharmacies. When they buy medicine, we're talking about buying and selling medicine. If I sell the medicine, the buyer will need a doctor's prescription. Well, that is already regulation. When they sell such medicine, it would have to be, it's already subject to regulation. Doctor's prescription is required. A proper record will need to be kept. For those in the full schedule, they will need to fill in a logbook before they can sell such drugs. And this will not change going forward. We're now talking about the pharmacies having to order the stock from the manufacturer before they can supply to the customers. When they order these drugs from the manufacturer, if they buy any drugs under the first schedule, they will be required to place the order in writing. For Part 1 poison, again, a written order would have to be sent to the manufacturer. That is, if they order any drugs, including Part 1 poisons, then the order will need to be done in writing. And the ASP will have to take this extra step when they order Part 1 medicine. We will now already have a first schedule and requirement for doctor's prescription. To put it simply, most of the poisons now can only require written orders.
But there are two schedules. The more potent ones are already required to be ordered in writing. And now we are going to extend this. We are just asking that the schedule be extended. It's going to have to contain a longer list. But the phase introduction is just something for doctors' clinics. Anything else that you need to get elaborations? All right. Miss Alice Mack. Chairman. Well, we have had a number of meetings already. Every time we will be talking about whether we support the bill or not. Some patients' associations have asked us to expedite the process. So can we proceed to the cross by cross? And if there are further questions, then we can deal with those issues separately. I think we have reached a stage whereby one side is very difficult, finds it very difficult to accept the other side's views. But this is the fourth meeting. We have certain focal issues discussed every time. Mr. Albert Chan would like to gain a better understanding of certain issues. He has ask the Secretariat to conduct some study, but would that allow the members to accept a certain position, and then you may want more consultation to be done, or you may not accept the government's stance, and the government may not be willing to move amendments. Then you can move your own CSAs, committee stage amendments. And if the administration agrees to withdraw the bill, then of course those who want the bill withdrawn will be happy, and that will be the end of our business. So I think I will allow members to express their views. If there's nothing new that you want to express, then I'll proceed to cross by cross. Don't be frightened by this big blue bill. A lot of the amendments are just about textual amendments. You may not be happy with the explanation offered by the administration. You can move your amendment. It's not that we can cannot change anything when we proceed to cross by cross examination. No, we can still ask for amendments. So I've noted the views of Ms. Alice Mack. We were talking about Mr. Vincent Fang's letters, Dr. Kwok. Points 7 to 9 have been discussed. Mr. Fang has asked for a written reply, so please give him a written reply. I have a duty to ask the administration to reply to Mr. Fang. All right. Do you have anything, any questions about the concepts, the principles involved in those issues, members? Well, we're not proposing as many amendments as members would assume. Well, actually, after page 87, they are all drug names. They're standalone drug names. And many of the amendments before that page are technical amendments. You don't, even for the requirement that orders be made in writing, is not in the bill. So I hope we can proceed to cross by cross examination as soon as practicable. We still have 10 minutes. If members have no more questions to raise, then I think we should proceed to cross by cross examination. We would go over the bill page by page, and you may wish to raise issues with certain clauses, and if a particular clause is considered controversial and there are outstanding issues, we may leave it at this stage. All right, so I will invite the Deputy Secretary to do the cross by cross with us. Mr. Lam, as a senior pharmacist from the DFH, he will be helping us with the cross by cross scrutiny. Yeah, please refer to the document number. Which one? Do you have the markup copy? Yes, the big bundle here. It's paper 13441314 bracket 02. Long title. There is an amendment to insert the words pharmaceutical products. Is the law relating to pharmacy and poisons. Which page are you on? We have paginated we have numbered the pages. It's 0001, Chapter 138, Pharmacies and Poisons Ordinance, and then we have an amendment to the long title to consolidate and amend the laws relating to pharmacy and poisons, and after the word pharmacy, we add pharmaceutical products. to reflect the coverage. And then there will be different titles added. We are going to add part 1 and also the heading preliminary. Please pause. Do you have questions, members? Okay. If there's no question, please continue. Interpretation. We add the reference to the Section 29, made under Section 29. And also we have a amendment to the term manufacturer on page 0002. And we explain what is pharmaceutical products. The amended definition would state that it would include processing and packaging, and such activities must be undertaken by a licensed manufacturer. And also on page 3, we have a definite technical amendment to the definition of authorized seller of poisons. It means registered pharmacies, border corporate or unincorporated body of persons. And also for retailers, we also change the pharmaceutical products. Medicine means any substance, combination of substances presented as having properties for treating or preventing disease in human beings or animals, or that may be used in or administered to human beings or animals, either with view to restoring, correcting, or modifying physiological functions by exerting a pharmacological, immunological, metabolic actions, or making a medical diagnosis. It's the same with the existing approach. Page 003, authorized seller of poisons. There's an amendment to that. That's the incorporation of business. And now it's expressed in written form. Under pharmaceutical product, because we have amended the definition of manufacturer by incorporating packaging. And therefore, under 1 here, we have 1A, what is meant by packaging. And in the subsection 4, we are going to refer to code of conduct and code of practice. And therefore, in 0003, we have definition of code of conduct and code of practice. And for the sake of simplicity, we are going to divide licensed wholesale dealer, licensed manufacturer, and also in subsection 8, we have forms or a record template in prescribed forms. To facilitate future amendments, we will tell them specify form. So we have a definition for specified form. And we also have a definition for court, because under 34A, we have a recovery of expenses provision. And we would like the term court to include a magistrate. And in 1A, the definition of packaging, because we have incorporated packaging as part of the definition of manufacturer. So we have a definition for packaging here. We will be talking about the code of conduct later. Please continue. 0004, Section 3, we add a Part 2, Pharmacy and Poisons Board before the provision. Pharmacies and Poisons Board. Since we have already set up a an office, drug office of the D of H, is an assistant director of health. It's no longer the chief pharmacist. So we have to amend section 3D, 32D, and also for 32I, a registered medical practitioner nominated by the Hong Kong branch of the British Medical Association is no longer true. So we would repeal section 3, bracket 2, bracket I. Page 5. No amendment for page 5. Page 6. The new code of conduct and code of practice. We have new provisions added. This would authorize the board to issue code of conduct and codes of practice, and it will be gazetted. And the days on which the code is to take effect will be specified. And if there are amendments, then the revisions will be announced in the Gazette, and also the date on which the revision is to take effect will be specified. And the Secretariat of the Board would provide copies for inspection. It's also stressed that the codes of conduct or codes of practice are not subsidiary legislation, and there may be different codes of conduct and different codes of practice. Well, this is a matter of concern to many members, and we still have half a minute left. Maybe with your agreement, members will pause here, and then we'll continue next time. And then let's see if members have any comments on the provisions covered. For those who have just joined us, please note that we have reached part 6 in our cross-by-cross examination. We'll continue next time. Anything in particular that the Deputy Secretary would say now? No? Okay, thank you. We need to schedule the next meeting later because of clashes of different meetings. Let's hope that we can have another meeting before the end of this month. Thank you.